All right. So I want to talk about one of the videos I made why I don't worry about using a Form 56 or a 56F. And, sometimes when I do videos, I think people really don't actively listen. And when I say that, it's not an insult to your intelligence. The problem is when people get into something, they listen with, as I call it, desperate ears. That means that you think that your situation is bigger than the world, and it isn't. It's just a situation that you're going through. So, someone in my video said, "Oh, that video didn't say anything about anything." But the reality is, in the video, I do tell them why I don't worry about using a Form 56. And I have to go with the cologne I'm wearing today, which is Imaginary Authors Cape Heartache. So, we'll go over this video. I'll play it for you, and then I'll tell you why this person could not understand this video and why people who are telling you a Form 56 don't know that you have to set up a court case for you to use a Form 56. Okay, so I'll go ahead and start with the video.
Had a consultation yesterday, and I want to go over something on the call that I missed out an explanation of this. And this is what's a trustee descent tort. And I know this will help you with your case. You know, even though we did the consultation, I think this is a kind of a good overview of why I told you to do either a cross or a counterclaim. Okay.
Now, the person who listened to this video did not understand why I said why you don't use why I don't have to use a Form 56. The reason why is because I stated that I can bring up the complaints or the issues in a cross or counterclaim. Okay, that means that all of the issues that you're bringing up on a Form 56, I can use the Form 56 after that if I bring up the issue. It is not a requirement that I use a Form 56. There are other ways to appoint people to take over or to be a fiduciary over your estate. But see, if a person actually listens to what I'm saying, they would find out that this short 2-minute video told you everything that you need.
Okay, so what a trustee descent tort is a trustee descent tort means a trustee of his own wrong. Okay, she slash he.
Now, if a prosecutor or a district attorney or an officer is robbing you of your estate, you can bring up a cross complaint or a counter complaint, bringing up their wrong, thus making them a trustee descent tort. It's that simple. People think that some Form 56 or involving the IRS is some gangbusters, but you have to know how to set up the IRS to take over your case. And usually the IRS ain't going to help until your case is over. And you know how I know this? Because I've already done this.
Is a person who, without legal authority, administers a living person's property to the detriment of the property owner. Ooh,
Now, doesn't that happen in every court case? It does. You cannot administer a live person's estate without consent from that person. This is why everybody in the court becomes a trustee descent tort and can be sued or can be elected under where we're going next, which is the Power of Appointment Act. Okay, so a lot of times when people listen to my videos, I'm giving you the answer in the video, just like the child support video, where I tell people the issue that you're having is the affidavit of parentage. If the people were not so ignorant, and I'm not saying everybody, but there are some people who are very ignorant, they'll watch the video, oh, yeah, okay, whatever. And I'm telling you, read the affidavit of parentage. That's the crux of the video. You didn't read it. So now they have an affidavit of parentage, which is an agreement that you sign and the mother of your child sign. You have a binding agreement. This agreement was formed way before they even got in child support, and you allowed it in as evidence. I can't tell you everything in a 2 minute, 1 minute video. Come on, please. So under the Power of Appointment Act, if you understand what a trustee desantor is, you can appoint anybody to be your trustee. You can appoint anybody in the public to be your trustee because they are automatically by default a trustee. This is why you have a district attorney. This is why the district attorney sues in the name of the state. This is why a police officer is a public official. This is why a judge is a public official. They are all your trustee desantors. This is what I'm trying to tell you. But people in the comment, you got to do a Form 56, and a Form 56 is this, or your video didn't say anything. Most people who are saying that have never used the Form 56 in court.
Yes. So
Yeah, I don't mean
the trustee
disrespect. I'm just telling the
desantor
truth.
is not regularly appointed trustee, but a but because of the interference with the trust can
See?
be held by a court as constructive trustee, which entails liability for losses to the trust.
Now, when you evoke trust law, you really need to know what you're talking about and what you're doing. Okay? So you need to understand how to select a fiduciary. Okay? If you read this, is very simple. You know, people always think that attorneys, sometimes there are good attorneys that give you light through a dark tunnel because I ain't learned everything by listening to so-called patriot, sovereign citizen, more act, whatever the hell you want to call it. I ain't learned all my stuff from that. I had to learn some stuff from attorney. Reading Yale reviews, reading all kinds of stuff. I read a lot of stuff. So look, fiduciaries can be appointed to serve you in a variety of ways. Three of the most common roles of a fiduciary include acting as agent or attorney in fact in a financial or health related manners during your lifetime, as the executor of your estate once you pass, or as your trustee. When preparing your estate plan, you may find that there is one person best suited and willing to serve as your fiduciary in all of these roles. Or more commonly, you may choose to appoint different individuals for your various fiduciary needs. There you go. So it doesn't say I have to use a Form 56. A Form 56 is just notice to the IRS. So after I set this up, I can send this and attach it to a Form 56F and send it to the IRS. Or I can make the person who I elect as a fiduciary report this information, this taxable information to the IRS. See, I think a lot of people are getting their information from people on court, like a lot of court stuff from people who've never been in court. You see what I'm saying? So, yeah, just because you elect somebody on a Form 56 doesn't stop a court case. There's other elements that have to go behind that. Okay, according their giftings and the dynamics of your family, when appointing a fiduciary, it is often wise to consider a successor or a backup person in case for whatever reason. So what happens is I had to learn this when I was assisting people with child support. And this is something I forgot to inform people. When you are suing somebody or uh, when you're going at people, you need to add their successor onto the complaint or onto the constructed trust reg. I'm sorry. If you don't, what can happen is they can switch the person around, and now your what you've done has not is not as effective as it was. Okay, so you have to do and their successor, which is the backup person, in case for whatever reason, which could be a judge, which could be anybody. Okay, your first choice is unable to act when the time comes. The name and the structure by which you choose to appoint your fiduciary can be identified in the corresponding formal documents drawn up for this purpose. So they're telling you you have to set it up for this. You can't just put a Form 56, or you can use the Form 56, but it's how you structure it. A lot of people need to understand that the IRS is separate from the court. And just because the IRS is what the IRS is doesn't mean that they can just bully the court. And I know this because I've shut down courthouses before. So I'm not talking from inexperience. I'm talking from experience.
Trustee Desantor is not an appointed trustee, but on takes on them to act as such and to possess the administers trust property for the beneficiaries. Now, if you understand why I told you what to do on that call, this is why I told you to do the cross complaint and how to set it up. Because once you set it up,
See, I'm telling you, if you're in a court case, then you can use a Form 56 and set it up correctly and elect the other party as a fiduciary. People are forgetting the fact that when you're in a court case, the disposition of or the transfer of the taxable termination hasn't happened yet. So a lot of people are telling you file 1099 OIDs, file this, file that, but the disposition of the case hasn't happened yet. So if they go through their proceeding and then they find you guilty or whatever, then what they do is they transfer the verdict onto your estate. So if you let the proceeding go, hint hint, you can bring a cross complaint. So sometimes people are so concerned about going to jail and all this other BS. It is what it is. But I'm telling you, through a cross complaint, you can either stop them from being able to do this, or you could affect it once this is done. And I'm telling you this because I shut down a court and got them in millions of dollars of tax trouble just by using this. But it didn't stop the case because a lot of y'all are taking advice from people who've never done this before. So we'll get into the Powers of Appointment Act. And it should be in most of your state codes. So you have to understand that you have the power, okay? A power of appointment is created or reserved by a person having property subject to his or her disposition, okay? It's subject to. So you have to set this up prior to filling out a Form 56. You can't just fill out a Form 56 and all your worries go away. Yeah, if you're dealing with low tier cases, the judge is going to be like, this isn't worth it. A lot of times people get like speeding tickets and stuff. That's not real cases. Okay. A judge can just say, this is not worth it. They're actually going to fight this one. So I'm just going to just eliminate the case. A win's a win, though. So the disposition which enables the donee of the power of appointment to designate within such limits as may be prescribed the transfers of property or shares or the interest in which it shall be received. So the people I've been training lately, we've already, we already we already got a different way of handling this, but this is just to clear up that video because sometimes people in the comment section, the problem is people do not actively listen. And if you actively listen, you're listening to the video and then you're like, okay, let me listen to what he's saying. And I'm talking about a cross complaint in that video. Okay, here you go. Manifestation of the extent to the power to exercise the power of appointment. Unless the person who was executed it had a contrary intention if creating instrument creates the power of appointment. Now you can do power of appointment orally, but due to the fact that how dirty that a lot of courts are, a lot of court officials are, I would probably put it in writing, to make it a lot easier for you. So the power of appointment that expressly requires that the power of appointment be exercised by any type of reference to the power of appointment or its source, the donor, which is you, the donor's intention in requiring the reference is presumed to prevent an inadvertent exercise of power of appointment. Extrinsic evidence as defined in subsection, which you guys don't probably need, may be used to construe the intent. So when you're dealing in court, you must have to have intent. Your intent must be put on the record. And a lot of times people don't do that because they're seeing people and most people don't even know how to do motions. They don't know how to file claims and these things. So if you don't know how to do a motion or a claim, you're going to go into court and you're going to wonder why you're not getting stuff done. Because I used to listen to people on the internet too until I noticed most of them are not showing you pleadings. They're not showing you forms. They're not showing you how to put a motion together. What are the requirements for the motion? What needs to be stated in a motion? They tell you that if you file a motion, you can completely submit to the jurisdiction of the court, which is not true. Because if I challenge the court's jurisdiction in a motion, I'm not submitting to the court's jurisdiction. So if the court dismisses that motion, I can appeal it. But there's other ways to get around court. But I'm just going over this for this. Okay. In the case of power of appointment and creating instrument manifest an intent to exercise the power of appointment, if the creating instrument purports to transfer an interest, see, listen what I'm saying, to transfer an interest in property. Now, if you have a court case, wouldn't you want to transfer that interest? But see, most of you guys are trying to claim the interest in the court case. You're not transferring the interest. You're not transferring it to the United States Treasury. You're not transferring it to the state treasury. So the interest stays into the case. And you remain liable because most people don't listen to my videos. They skim over and they're like, oh, yeah, yeah. And then they're in the video trying to figure out the remedy instead of listening to the video on his face because I'm giving you the remedy. I've already given people the remedy for child support. And people don't listen. So in the appointive property, which the donee would have no power to transfer, see, no power to transfer, except by virtue of the power of appointment, even though the power of appointment is not recited or referred to in creating the instrument. See, you guys need to know this stuff because this is going to help you in and out of court. Okay. Or if the creating instrument, either expressly or by necessary implication from its wording, interpreted in the light of circumstances surrounding its drafting and execution, manifests an intent to exercise the power of appointment. What? So how come these people who are telling you to use Form 56s are not telling you you must develop documentation to express your intent to do a power of appointment? Now, I'm not saying you can't put this on a Form 56 or Form 56F, but you have to provide notice. Notice must be provided. Now, if you attach that notice to a Form 56, there you go. Now you're cooking with grease. But you really don't need the Form 56. Remember, that's just the IRS's form. So if there is a general power of appointment exercisable by will with no gift in default in the creating instrument, a residuary cause or other general language in the donee's will purporting to dispose of all of the donee's estate or property, operates to exercise the power of appointment in favor of the donee's estate. But in all other cases, such language, such a clause or language does not in and of itself, it does not in itself manifest an intent to exercise a power of appointment exercisably by will. Now, so you got to understand when you're reading this, you have to go to what is exercising the power of appointment. Okay, the capacity to exercise a power of appointment. A power of appointment can be exercised only by a person who would have the capacity to transfer the property covered by the power of appointment. Okay, kind of instrument and formalities of execution. A donee can exercise a power of appointment only by an instrument which meets the intent of the donor. So if the instrument doesn't protect you, then it doesn't qualify. The donor has control of the power of appointment, not the donee. The donee has to do what the donor will is. So whatever the donor expresses his will, meaning his intent, the donee has to follow it. Okay? And what happens is you guys go into court and you allow these people to bully you out of your position because they know you don't know what you're doing. So you have to have understanding. I can't teach you understanding. I can teach you knowledge and wisdom. Can't teach you understanding. Understanding comes through study and application. Okay. Donor as to the kind of instrument and formalities of execution. If the power of appointment is exercisable by will, this means a will executed with the formalities necessary for a valid will. A written instrument signed by the donee is sufficient if the donor fails to require any additional formalities or fails to indicate a will. But if the power of will of appointment is to appoint interest into land, it can be exercised only by an instrument executed with sufficient formalities for that purpose. So you can go through your own state's Power of Appointment Act, releases of appointment. This will to show you how to set things up. So then you have to understand what the definitions. Who's the donee? Who's the donor? Donor means the person who creates or reserves the power of appointment. This means you. So if you create the power of appointment, you can control your court cases. You can control it. It doesn't always have to reference a power of appointment, but you have to reference the term donor. These are terms that are used in the gift and estate tax. And if you understand, I already have a video talking about the gift and estate tax. That's what all this is wrapped up under. So I'm going to go back to this video because some people say, oh, I'm not giving any information. This is basically telling you that everybody becomes a trustee de santor. So all you would have to do is name them in a cross complaint or a counterclaim instead of just a Form 56. See how simple that is? So that's the problem with a lot of people is they come to page, they expect to listen to a video and get all the information instead of actually listening to the video and listening to the information that's conveyed in the video and then doing your own research and due diligence. Then you would understand I already gave you the answer because this is how I don't have to use a Form 56 because I can elect and appoint anybody as a trustee, or I can appoint them as an executor. I can appoint them as anything I want to and say that I have a beneficial interest. Remember, when you're being sued in a court case, the only person that's suing you is under the state. So they're suing you. Now, if you bring it in under a corporation and they bring in an attorney, then the attorney is acting as an agent on behalf of the bank, but they're really an agent for themselves. So then they add what is called a attorney's fee. Okay. Once they add an attorney's fee, they become part of this. Okay, because they're receiving a benefit. So they become trustees de santor.
Each one of the people in that case becomes a constructive holder of taxable property, meaning due to a taxable termination, they all become trustees de santor, meaning they're all liable to settling the taxes and they have an obligation to the United States Treasury or the U.S. government, also the state. So whenever you set up the people in the way that I showed you to, you see the power of this. I'm out.
Now, with this video, right? With this video, with sorry, my thing went a little crazy. So with this video, I'm trying to let you guys know you got to look into your state and you'll see how to appoint these people as your trustees or how to appoint these people to handle your dealings because anybody in the public is a trustee. When your name is in the public, you're a trustee. Now, people use the so-called straw man name as the so-called trustee, and it really isn't. It's just when your name is phonetically used. I mean, as it's phonetically spelled, is used in the public. You become a public trustee, and I'll explain to people why you become a public trustee. And see, it's very easy to understand, but I'll show you. And I usually show this to everybody I do a consultation with, and most people don't get it. All right, we'll go to section 4 of the 14th Amendment. The validity of the public debt of the United States authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing insurrection or rebellion, shall not be questioned. Okay? So when they take your private court case and convert it, remember, I have a video talking about conversion. Okay? They take it and convert it for a business process or a business need. The validity of that debt can't be questioned. Okay? But neither the United States nor any state shall assume or pay any debt or obligation incurred in the age of insurrection or rebellion against the United States, or any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. Okay? So you understand when you get a court case why they always turn it into a public court case, because they're putting you under the 14th Amendment. Okay? If you don't understand the 14th Amendment, I might make a video and explain it how everybody's all uproar. Oh, the 14th Amendment is so illegal. It's all okay. I'll make a video about the 14th Amendment, but I really want y'all to understand this because sometimes I do videos and people always say, "You didn't say anything." And I'm like, dude, just go read the form. Go read what I'm saying, especially in that video where I'm talking about child support. It basically tells you on the form how to get rid of child support. I'm out.